Your Lordship.
Yes.
Yes, Your Lordship. Your Lordship, this the present matter was last listed on 2nd of April 2025 and on that particular date, Your Lordship, it was listed for final disposal on 23rd of April. But thereafter, Your Lordship, 2 times the matter has been listed and it could not reach the board, or either it was deleted, Your Lordship. The urgency in the present matter is that, Your Lordship, the livelihood of the petitioner is being affected.
Okay. We'll give you some date. We'll give you some. Give us some. Okay?
Yes, Your Lordship.
Thank you.
Obliged.
Please, please, my lords. Let's.
Any developments?
Yes, my lords. Let's in the. Well, it's in the cancellation of bail, notice has been issued. It is now listed on in October 14th. And the respondents appeared and they sought time to file their reply. It's a cancellation of bail.
When was the notice issued?
I have the copies on 8th of September.
You all didn't impress upon the court that there is an urgency. It's a very serious offense.
We did, my lords. The respondent was appearing and he sought to file a response, my lords. So 14th of October it is listed.
Bail of how many accused is now sought to be cancelled?
My lords, one.
One.
Two, my lords,
Two.
because 4 are already in custody who had antecedents, prior antecedents, they are in custody.
And what type of conditions have been imposed to ensure that they do not flee away or they do not tamper with the prosecution witnesses or something like that?
Well, it's,
Grant of bail,
yes.
any conditions, appropriate conditions have been imposed?
Well,
Have you
it's,
checked up?
yes, they had, my lords, but they are appearing.
What type of conditions?
My lords, I have the orders by the trial court.
Just tell us, how many conditions are imposed? Any condition with regard to marking of presence at the police station?
Well, I'll just say it. It said that the accused shall not tamper with the evidence and shall not influence,
Okay.
shall not indulge in any other criminal activity.
Then
They shall inform the court, IU-SHO, about any change in her address or address of her surety. That is it, my lord.
that's it.
Yes.
Now they are from which state?
My lords, they are from Delhi itself.
They are from Delhi.
Yes.
Have they furnished their permanent residential address?
They have, my lords.
Have you inquired whether they are actually residing at this particular address or not?
Yes, my lords.
Are you keeping a watch?
Yes, my
on
lords.
that moments?
Yes. We are doing that, my lords.
At least when notice was issued,
Yes.
you have requested the court that till appropriate orders are passed, tell them to mark their presence once in a week
My lords.
so that we get to know their moments.
Yes.
What else?
My lords, one accused which is absconding, he has been declared PO. Out of proclaimed offender, my lords. So out of 13, today, my lords, 4 who were involved in previous FIRs had antecedents, they are inside. 2 we have moved for cancellation. The others were granted bail because there were no antecedents and charge sheet had been filed. My lords, now today the charges are framed on this 20th only. The charges against all 11 have been framed.
Which matter? This is.
This present matter, my lords.
Oh.
Yes, charges have been framed, my lords.
Against in all 11.
11, and because the 12th one was arrested recently.
Out of 11, 1 is absconding.
Out of 13, 1 is absconding.
13.
Yes.
1 is absconding.
Yes.
How many are in judicial custody?
4 today, my lords.
All others are on bail.
Yes, my lords.
So in all,
Now there are 5th, my lords. Komal Verma, who was arrested later on, is now also in judicial custody. So there are 5 now.
so 5 are in judicial custody.
Yes.
And how many are on bail?
6, my lords. 7.
Out of 6 on bail,
Yes.
the cancellation for one of the accused is
2.
going. 2.
Yes, 2. 2 is going on. And
Okay. What else?
my lords, one more thing, learned amicus said that the IVF centers also to be investigated. In our investigation, my lords, nothing has come against the IVF centers. So these four who were previously involved in the other FIRs, they were 4-5 years ago, they were involved.
IVF are private centers.
Yes, yes,
If infants are picked up from hospitals,
yes,
they could be picked up from IVF centers also.
yes. But
As we have always told you, this is
a bigger nexus.
a network operating across the country. Unless you are able to break that network, you won't be able to reach to all these people.
Well, it's in this.
It's a big challenge.
It's,
It's a big challenge. This is not confined only to Delhi.
my lords.
Of course, we are now looking into the cases registered in Delhi.
My lords.
But it's a big challenge for the country. Trafficking, the big problem.
Well, it's these accused were previously 4-5 years ago, they were working as egg donors in the IVF centers. However, in this particular crime which they have committed, they have not picked up from the hospitals or IVF centers. They have taken it from the parents themselves.
What about the trial so far as that Pinky versus State of Uttar Pradesh is concerned? Is it in progress, going on?
Yes, my lord, it is going on.
Witnesses are being examined?
Yes, it's going on day to day. Your lordship had ordered day-to-day trial. That is going on.
Okay, that's good. Anything to be conveyed to us?
Yes, my lord. I had given a note last time. I shared with the ASG as well, which was basically about what is the concern that they had.
Yes, my lords. It is in the note, learned amicus is asking about the previous FIRs. There we have indicated in our table that there either it is on the stage of prosecution witness. So in all the other FIRs, the trial is going on as on date.
What must?
As an extra.
This information which you have furnished to us,
Yes, my lords.
it relates to FIR number.
This present FIR, my lords, which is 178 of 2025, PS Uttam Nagar.
Uttam Nagar.
Yes, my lords.
Same.
And the rest 3 FIRs,
Have you
Where-
said anything in writing about this?
my lords, my previous affidavit takes care of the.
Do you have the affidavit, Ms. Bhatt?
Yes, my lord. After it was filed on 4th of September. In response to the affidavit, I had made this note saying that these concerns are not addressed. My lord, the special attention had to be paid, focus had to be paid by them because they are, my lord, it's rather casually being said that these people are working with IVF centers as egg donors. My lord, the Act bans it. Commercialization of egg donors is not permitted. If an IVF center is employing people for the purposes of egg donation and subsequently they turn out to be traffickers of kidnapping and then selling infants, my lord, this nexus has to be seen. Lord, I'm not for a moment suggesting that an IVF center is involved in trafficking, but the investigation has to look into that. How can they employ egg donors? My lord, it's in violation of the statute. And that is something I'd flagged for them.
What do you mean by employing the egg donors?
My lord, under the
What sort of employment is this?
we don't, my lord, that is, they're just saying they're employed. We don't know what kind of employment. Were they employed as staff?
Employed, they were, my lords, donating their eggs in those IVF. But that was 5 years ago. In the present FIR where we have conducted investigation so far, the parents, my lord, sold the kids.
Take down. We heard Ms. Aparna Bhatt, the learned amicus, and Ms. Archana Pathak Dave, the learned ASG, appearing for the Union of India.
State of NCT.
Sorry.
State of NCT Delhi.
And State of NCT Delhi. Insofar as the FIR bearing number 178 of 2025, registered with Uttam Nagar Police Station, Delhi is concerned, we are informed that out of 13 accused, 1 accused has been declared as a proclaimed absconder. 5 accused are in judicial custody as on date, having regard to their past antecedents. 6 accused are on bail. Out of 6 accused who are on bail, the trial court is hearing application for cancellation of bail with respect to 2 of.
High Court is hearing, my lord.
High Court is hearing application filed by the state seeking cancellation of 2 of the
Yes,
accused persons.
yes.
We are informed that the High Court issued notice and has kept the matter now in the month of October. We request the High Court to look into the matter at the earliest, having regard to the serious nature of the crime.
Give that to notice.
It is needless to say that ultimately the application filed by the state has to be decided on its own merits. Good one. Next. In pursuance of our order dated 18th of August 2025, the state of and city of Delhi has filed an additional affidavit dated 4th September 2025. According to the learned amicus, the affidavit fails to take care of the following. Yes, please.
Section 14. I just, well, section 33 of the ART Act is, that, my lord, it was in the earlier note. This note doesn't contain the section. I just want to, well, I'd given an earlier note which your lordship had reproduced in the previous order.
We should incorporate this now.
Yes, my lord. Yes, I'm saying section 33 of the ART Act, my lord. I'll just give the name of the act also, the learned court master. Just give this.
Pass it on.
Section 33.
Kitna le lo?
You have a copy, give it to Archana also.
33? 33?
33, my lord. My lord, I was only submitting that this is a matter of investigation and this cannot be taken very casually. If there are people working in an IVF center.
What are you trying to convey showing us this 33?
My lord, I was only showing, my lord, in their affidavit, both the affidavits, they make a, they make a submission that these 3 accused were at one point in time, they say some time back, working in an IVF center. They don't say in what capacity. In another part of the affidavit, they also say that one of them was an egg donor. My lord, and commercialization is prohibited under the Act. And my lord, in most of the IVF is a very specialized science and medical doctors are involved in it. In the IVF centers, there has to be a doctor who's familiar with the process and who's administering treatment to couples or who takes charge of this sperm and eggs and they're stored and there's a very scientific process the Act enumerates. But my submission is that the section 33 says any medical geneticist, gynecologist, registered medical practitioner or any person shall not abandon, and my lord, the next one, B, your lordship may see that, sell human embryos or gametes, run an agency, a racket or an organization for selling, purchasing or trading in human embryos or gametes. But I'm only submitting that they ought to investigate this because if there are people meeting and conspiring in an IVF center, that's the only.
Such centers are there in Delhi.
My lord, I have to find out, my lord. There are too many, and I can just find out.
At this stage,
At the stage given up.
amicus invited our attention to section 33 of the Assisted Reproductive Technology Regulation Act 2021. Section 33 reads thus, quote it. According to the learned amicus, the investigating agency must pay due attention to this particular provision and undertake extensive investigation at all IVF centers across the state of Delhi to ensure that the provision of section 33 is not being violated in any manner. We direct the state of NCT, Delhi, to look into this aspect very seriously and give us a status report of their investigation in this regard on the next date of the year.
My lord,
Right?
May I make another intervention subject to my Lord's convenience? My Lord, there is, my Lord, during the course of this, preparing for this matter, one did a desk review of what is happening. And my Lord, we found another case from Delhi. My Lord, I just wanted to tell the the learned ASG that this has to be looked into. On 9th of September, infants were rescued, and in this case, a doctor has also been arrested. And my Lord, the police have undertaken this action. It may be connected with this FIR, it could be with some other FIR.
Where is the information in this regard?
My Lord, I have made a table, but it is actually.
Just give it in the form of a note.
Yes.
By end of the day, we will incorporate.
I'll share it with the learned ASG.
Look into it.
It's not part of it.
A doctor has also been arrested, is what the information says.
After 6 weeks.
My Lord, a small aspect, when your Lordship passed this judgment, Pinky versus State of Uttar Pradesh, in paragraph 87, my Lord was pleased to direct that the registry should forward I'll read that portion, my Lord. The portion says, the registry is directed to forward 1 copy each of this judgment to all the high courts and 1 copy to all the state governments. So far as state governments are concerned, 1 copy each of these judgments shall be forwarded to Principal Secretary, Minister of Home Affairs, and Principal Secretary, Minister of Women and Child, respectively. Registry shall notify this matter once again in the month of October 2025 to report compliance. My Lord, if your Lordship recollects, there's a series of directions passed in this case, my Lord, because your Lordship had noticed that a child was kidnapped and then sold in a different state.
The same matter.
Yes, my Lord, this direction was for compliance. Your Lordship had said it should come in October. I'm just drawing your Lordship's attention to that.
Our attention was also drawn to para 87 of our judgment rendered in the case of Pinky versus State of Uttar Pradesh and another, wherein we said that the matter be notified once again in the month of October 2025 to report compliance of various directions, right?
Yes.
A status report in this regard shall also be placed on record by the next date of hearing. Okay? Thank you.
Obliged.
Give a particular date.
The Lordship consider top of the book.
First matter on the book.
Yes.
Next.
Well, it's item 8. I request 1 week time. Well, it's learned. ASG wants to verify if this.
Restoration.
Yes, but we want to verify if this circular is struck down by a judgment of this court or it is still applicable. Circular, CPTT Circular 5 of 2014, dated 11/2/2014.
A request is made on behalf of the revenue to keep this matter after 2 weeks, as some inquiry is required. Put it after 2 weeks.
Very good, Father.
May I please approach? My lord, the respondents, they are my neighbors on the backside. They raise a construction without leaving the mandatory setback, my lord. They, in fact, my lord, action was initiated against them by the municipal corporation. They file a suit. The finding returned is that they have violated and they are not granted injunction.
What is this section 307?
Yes, my lord. Yes, my lord. May I, you've got copies?
Yes.
Yes. May I pass it on, my lord?
So you moved this application before whom?
Before the authorities, my lord.
Against which a revision lies in the High Court?
Yes, my lord. The division lay before the district judge.
You went to the trial court only.
Yes, my lord.
After they withdrew the second appeal.
No, the impugned order is of the High Court.
I know, but that arose out of a.
May I tell your lordship a little sequence, my lord? So they file a suit which is dismissed so far as relief of injunction is concerned. The first appeal is also dismissed. Then, my lord, they go to the High Court and second appeal. While that is pending,
They withdraw that saying it's compromised.
what they do is they enter into a compromise. But before that compromise, my lord, I file a writ petition saying that they are going to settle in contravention of section 308. The High Court passes an order in my favor that no compromise shall take place or no settlement shall take place in violation of 308. Despite that, my lord, they enter into a compromise, and on that basis,
Who entered into the compromise?
the private respondents with the municipal corporation.
Now come to para 9.
Para 9 of the,
The impugned order.
yes, ma'am.
Even in the application in the section 307 subsection 5, that is your application.
Yes, ma'am.
The applicant has averred that the non-applicants 1 and 2 have compromised the matter with non-applicants 3 and 4.
Yes.
So who are these 3 and 4?
3 and 4 are the municipal corporation.
Fine. And
Yes.
the non-applicants 3 and 4 have compounded the illegal construction illegally, just contrary to the provisions contained in 308 capital A and B.
Yes, ma'am.
Hence, compounding is illegal.
Yes.
So what is the nature of this compounding?
That's what I'm saying. The violation is that in the setback, my lord, your lordship knows in a building you have to leave a setback from the boundary.
Correct. Now, this is the only remedy with you?
That is the only remedy, my lord. My lord, I've filed a writ petition.
Compromise is valid. What is this setback? Setback, sir?
In locally, it is called a shade. It's actually a shade bank.
Setback.
Shade bank. So, my lord, probably to leave some area shade.
Sangi, what is the distance? What is the?
My lord, before the trial court, this issue came up. The trial court notes that we are saying it is 5 feet. They have left they claim that they have left 2 feet. The municipal corporation inspects and says it is actually only 1.5 feet.
This offending construction.
Yes, ma'am.
Is the rear part of your house a adjoining part of your?
It's rejoining or rear? I think it's rear. It's at the rear part.
So perhaps your washing area and all behind your house.
Yes, my lord.
And this construction, there's a gap of about 2 feet.
Yes, actually 1.5 feet. That is what the trial court found. They are supposed to leave 5 feet.
Is
My lord,
this
it affects my air, my light, my privacy, everything.
So this has something to do with your easementary rights. Under 307(5).
Yes, ma'am.
Could these rights be adjudicated and
My lord,
decided?
307 says if you raise construction in contravention of the sanction, his sanction does not permit him to raise
Do
construction.
you have the compounding order, regularization order?
Unfortunately, my lord, that we don't have.
If
that we
you
don't have.
heard Mr. Vipin Sanghi, learned senior counsel, appearing for the petitioners. Issue notice. On the returnable date, we want the respondent numbers 3 and 4 respectively to depute a responsible officer with all necessary records, including the maps, plans, etc., and also the order passed regularizing the alleged illegal construction put up by the respondent numbers 1 and 2. Give them dust.
Yes. Much obliged. Great.
Yes, sir.
Mr. Luthra, Mr. Luthra is leading me. He's on.
But if I may, my lord, with your lordship's permission. My lord,
What is the offense, Mr. Luthra?
Lord, no offense, this one, not
What is the
for a
offense?
change. Not an offense, not this one. Not an offense, not electricity for a moment, Lord. This
No.
time neither is there an offense, nor am I an offender, Lord. If I may, there is a petition filed regarding an high tension construction under a high tension, which is adjacent to my property on public land and private land. We move a representation, which is a P2. There's no action. We go to the single judge. Single judge calls for a report.
You want action
Strange.
to be taken, Mr. Luthra? You want
Yes, Lord.
action to be
Yes,
taken?
Lord. We want action to be taken.
Or
Lord, we
the
want action to be
is
taken.
against you.
No.
No, we want action to be taken. Not that we had left open
Against
space.
unauthorized construction.
Yes, my lord.
Who has put up this unauthorized construction?
My lord, it has been put up in collusion by local people, not in collusion with the municipal authorities, because when the report is called at page 42, the municipal, Lord, it's housing which has come up, not house.
Two-storied buildings.
Two-story building, Lord, under the high tension cable, which is not permissible. It's a safety hazard. So I made the representation. You can't have this. The court calls for a report, single judge. The report by the KMC is bizarre, Lord. It says that first floor construction is going on a different address. The West Bengal Electricity Board gives a very clear report that this should not be allowed. And if my lord sees page 43 for a moment, despite this, I'm facing adverse orders from single judge and division bench. Division bench, of course, says I'm trying to vacate people.
1 minute, 1 minute. In their land, they have set apart 12 into 350 feet for high tension wire to their own land. So high tension wire force being here, you can't construct anything below. But some encroachers have come and constructed here. Then they complain. Report is called for. Municipal corporation, according to the pollutes, and says not here, but in some other unauthorized company. Demolition order is given for this. Whereas the electricity utility also says construction is here, right under the high tension wire. They are alleging pollution between municipal corporation and this unauthorized.
People who have heard Mr. Siddharth Luthra, learned senior counsel, appearing for the petitioners. Issue notice. In the meantime, there shall not be any further construction.
Deeply blind.
Just a minute. On the returnable date, we want the respondent numbers 2, 3, 4, 5, 6,
And 12 not. 10 and 2.
do you need these many respondents?
Who is
Not-
Who are the main respondents?
who is the main one? Others are official.
Main is not municipality, not municipality. If my lord just says number
And the
1, number 2,
electricity and the electricity board. They are the thing.
yes,
They are
that's
supporting.
12 not.
They are supporting.
They are
They're
supporting.
supporting.
Who are supporting you?
The
12.
respondent number 12.
Respondent number 12 is supporting you.
Yes, my lord, the report is there.
And-
at the file.
and according to you, who has colluded?
The municipal
And
corporation.
respond municipal corporation.
And colluded with which respondent?
Those are
Not-
the local inheritance, so they are encroachers.
They are not parties. Encroachers are not parties, your lord.
Now the authorities, they want to pull down your structure also.
Authorities
No,
want
no.
to pull down some other structure when they want the structure in their premises to be pulled down.
And the division bench says that we want private people vacated, not which is completely
On
wrong.
the returnable date, the respondent numbers 1 and 2 respectively shall depute a responsible officer with necessary records to remain personally present before this court. And at the same time, we also direct the respondent number 12 to depute a responsible officer
Grateful, Lord, deeply obliged. Deeply obliged. Really.
Your Lordship, this is a very peculiar matter. This pertains to cancellation of our GST registration. What had happened is, first there was a show cause notice issued. We are Thomas Cook Tours and Travels, situated in Srinagar. There was a show cause notice issued by the state officers first, saying that you are not found to be in the place of business. This was during COVID.
is Thomas Cook not now gone? Thomas Cook is no longer in this business of.
It is still there. Your Lordship, this is period 22, 23, etc. And they are still there. They are operating still.
But the ground on which your registration came to be cancelled is that the business premises were.
Yes, that is what they have said. So, my lords, can I just, Your Lordship, so this is the problem. Your Lordship, on a particular date, that is on, the matter when show cause was issued saying that you are not found to be in your place of business. Then we went to the appellate authority, registration was cancelled.
Registration is only with respect to the state of Jammu.
Yes, yes, this is only one registration because in each state we have to take a distinct registration. We took the registration. This was COVID period. We were actually there. Some people were on field. They came for some inspection. We explained it to them. In fact, the state authority actually during hearing before the appellate authority says, yes, they were found in that place of business. So in the first round, they actually decide in my favor and they say, yes, you have been found to be in your place of business. And this is at P9, Your Lordship.
What is the date of the order
Yes, sir.
cancelling the registration?
Your Lordship, my order was cancelled twice over. The registration was cancelled twice over. That is the problem.
Why twice over?
Yes. So, Your Lordship, first it was cancelled on 10/6/2022.
What happened thereafter?
Thereafter, we filed an application for revocation that was decided by the appellate authority. And Your Lordship, at page...
On which date it was decided?
This was filed, it was decided on 22/8. Within about 2 months. It was decided 22/8/2022.
Allowed or rejected?
Allowed. And on 22 I filed, 29th it was allowed. In fact, he says that the business was existing on the registered premises. This is at P9. Again, within 15 days, they issue me another show cause notice saying you are not found in the place of business. So the very same, the appellate authority issues, restores my registration, they restore it. Then within 19 days, again, Your Lordship, on 29/2022. Yes, Your Lordship.
How your case is,
Yes, Your Lordship.
I have shifted my premises.
Yes, Your Lordship.
Give me an amended registration.
Yes, you so yes, so now my
You were saying you have shifted, you kept saying no.
No. Your Lordship, I shifted in 2023. That is the position. The second show cause notice, my lords, I'll just hand over an abridged list of dates.
So what is the continuity that you will lose? ITCs you will lose.
ITC full we will lose. Entire ITC.
Issue notice. Give her dusting.
Obliged.
There's a delay of 312 days.
No, it is from, we had filed a modification application. The modification application stood decided only earlier. March 2025 it was decided. We filed in July 2025.
Thanks, ma'am.
Obliged. Much.
Item 12, dispute is in respect to demarcation of land. Because all the three courts non-suit me on the ground that I have not made an application for appointment of a court commissioner. Because court commissioner cannot demarcate the land.
Mr. Malkan, why do you bring such matters?
Because my own land,
This
the
is not
road has been
fair.
constructed, my lords.
This means next matter.
Encroachment on my own private land, my
Mr.
lords.
Malkan, we have made ourselves very clear. We are not going to entertain such petitions. Next
Right.
matter.
Oh, right.
My lords, in the EBC proceedings, my lord, resolution plan has been approved by the Committee of Creditors and it is placed before the NCLT. Orders could not be passed, my lord, because in the writ petition, the Honorable High Court has passed an interim order directing the NCLT not to pass any final order at all. So this, we have filed a petition, this order, my lord, was passed on 16/9/2021. My lord, the matter has not been disposed of, my lord, though we filed a petition seeking modification of the interim order. My lord, in the year 2022 itself, IA number 688 of 2022 was filed on 8/3/2022. The Honorable requesting the Honorable High Court to modify the interim order and to allow the NCLT to pass further orders on the resolution plan which has been approved by the COC.
There's a delay of 581 days.
Plus we were waiting there, interim order.
Where?
Interim order passed in the year 2021.
The modification is still pending.
Is still pending.
The NCLT proceeding have been stayed by the
State, yes.
That can't be done. We can ask them to take up the modification.
Correct. That's my prayer.
Petition is with the
That's some IBC posting.
We'll ask the chief to constitute a bench of Justice Bindal and Justice Bagchi. They will hear this matter.
Yes. Well, that's my prayer is very limited, Mullets. The High Court may take up my IA, Mullets, seeking modification or cancellation of the interim order and dispose it of, Mullets. Matter is pending for about 3 years, Mullets, more than
What is that IA number?
Mullets, IA number 688 of 2022.
IA number?
IA number 688, Mullets, bar 2022. In WP number 1389 of 2017.
688 of 2022 in
Mullets, WP number 1389 of 2017.
WP or CWC?
WPA. Yes.
WPA.
Number?
1389 of 2017.
So today,
Yes, Mullets.
what is challenged before us is?
Mullets, the interim order of the Honorable High Court might passed in the writ petition.
Even that order, continuation of the order.
Continuation.
Adjournment order.
Continuation.
That interim order is happily lying in annexure P4.
Yes. 2021. 16/9/2021.
You're not telling that.
You have not challenged this 12th of October 2020.
It's only an interim order. Mullets. We have prayed for vacating the order. We filed, that is why we went to that court itself.
So there is some interim order passed in this, some really interim order in the order of 12th October 23.
16/9/2021, Mullets, interim order restraining the NCLT from passing any final order.
Where is that order?
That order you also will find, Mullets, at page. Mullets, page Mullets 72, you also will come. 72. And the operative portion, Mullets, last 2 lines.
What is the name of your client? Kiran Malhotra?
Mullets,
What is the name of your client?
my Devinder Singh, Mullets, he is a resolution professional.
Who is Alchemist Township India Limited?
Mullets, that is the company, Mullets, against which Mullets proceeding is now pending before the NCLT.
Resolution pro-
I'm the resolution professional. That order of stay, Mullets, you will also will find at page 72, Mullets, last 2 lines.
Same, the modification in accordance with law, that's all.
That's all. That is our prayer. However, we direct that no final order shall be passed by the NCLT during the pendency of the present writ petition before this court.
Yes, not challenge the real interim order.
This October 12th October. The learned senior counsel appearing for the petitioner, resolution professional. Our attention was drawn to an order passed by the High Court of Judicature at Calcutta, dated 16th of September 2021, annexure P4 to this petition. The operative part of the order dated 16 September 2021 reads thus. ये last 3 paragraphs really. Right? Thus, it appears that the NCLT was restrained from proceeding further with the CIRP.
Not passing, right?
In
Not
other
to pass
words,
final.
restraining the NCLT from passing any final orders. Full point. Such circumstances, the petitioner, in his capacity as a resolution professional, has moved an IA bearing number 688 of 2022 in WPA number 1389 of 2017, and the same is still pending for hearing, right?
Correct.
We dispose of this petition with a request to the High Court to take up IA 688 of 2022, filed in WPA number 1389 of 2017 at the earliest, and see to it that an appropriate order is passed in accordance with law after hearing all the parties concerned. Let this exercise be undertaken and completed within a period of 1 month from today.
Great one. Very good.
My lords, this is a case wherein ratio of distribution under the resolution plan was challenged to be unfair and non-equitable. Because, my lords, the appellant department has only received 50,309 rupees out of admitted claim of 2 crore something, my lords.
The claim for 13.61 original.
My lords, even, my lords, it was intimated, but my lords, 2.61 crore has also not been considered. My lords, kindly.
Considered in accordance with the plan.
My lords, I am going to refer to a 3-based judgment, my lord, with humble submission with regard to Regulation 38 Clause 1, my lords, which says that operational creditor has to be given priority to above financial creditors. My lords, kindly see page 79. So, my lords, 100% resolution has been given to financial creditors, and the government due, not even 1% has been given, my lords, under the resolution.
That only satisfies section 30 under IBC.
My lords, yes, my lords, it says fair and equitable distribution.
You're right.
My lords, with regard to
What has fallen from my lord, come to para 11 of the Injunction. You need to make us understand this.
yes, my lords.
Read it.
My lords, page para 11. It is therefore abundantly clear that though the substantial time had elapsed, the appellant had clearly failed to exercise exquisite due diligence in filing their alleged my lords, you may set aside my additional claim. But even then, my lords, my 2 crore 61 lakhs is admitted claim. And my lords, what has happened is that I had initiated fraud qua this company, respondent number 1, prior to the moratorium. So there was a fraudulent GST case which was lodged under section 74 of CGST Act, my lord. Now, what has happened is that, my lords, after they've got the resolution plan approved on 30th August 2023, he is claiming from me 4 crores 25 lakhs as input tax credit, which I was already dealing into before the moratorium stay order had been granted. So I have left with no remedy, my lords. My case of fraud was being looked into by the department.
On this point, 2.61 and the rightful settlement, page 11, para 16, last 5 lines.
Page 11.
See what the liquidation value is and how as an operational creditor you have got your due.
The total liquidation value is 42 crores.
Yes, ma'am.
68,412.
Yes, my lord.
Now read it.
The appellant in the plan exceeds the entitlement of the appellant is being the operational creditor specified under section 53 of IBC. That being so, the appellant cannot complain about the treatment meted out since they have received the minimum entitlement. My lords, I completely agree with this, but I would like to refer to my lords 3-bench judgment with regard to regulation under 38 clause 1. My lords, firstly, I would request you to please come to page 71, my lords. 79, sorry. So, my lords, the last para, my lords, have it? So, my lords, the last para, it states regulation 39 clause 1, my lords.
Annexure.
They are saying,
Annexure.
my lords, this is annexure number. This was the order of approval of resolution plan, my lords. This is annexure number A2.
Yes.
The order by which the resolution plan gets approved, my lords. So, my lords, page 79 is where they have confirmed under regulation 38 clause 1 whether the amount due, my lords, have it? The last para, my lords, down.
Right.
Whether the amount due to the operational creditor under the resolution plan has been given priority in payment over the financial creditor, my lord, and they say yes. Now, my lords, with regard to the 3-bench judgment of Esser Steel, my lords.
What is this document? This looks like some FAQ.
My lords, this is the judgment on basis of which the resolution plan has been approved, dated 30th August 2023. This is on the basis of which they have approved this resolution plan, my lords. So, my lords, now, my lords, if I may take you to Acer Steel to explain what regulation 8 clause A was defined by the 3-bench judgment, my lords. My lords, kindly see page 36 of my SLP, my lords. The last para of page 30C, it's 36, it says, my lords, whether the court below failed to consider the 3-bench judgment of Honorable Supreme Court in the case of Acer Steel India, Committee of Creditor versus Satish Kumar, 2028 SSC 531. Now, my lords, this explains how the resolution
I don't find any.
My lords, today I'm left remediless because they are filed a writ petition or claiming 4 crores 25 lakhs from me. I have only got 50,000, my lords, under IBC. I am not even allowed to initiate the proceeding which was prior moratorium. How can they get the blanket relief, my lords? My lords?
Which para of SR Steel you want? You are citing SR Steel.
Yes, my lords. Para, my lords, 46th right number, my lords. I have referred 72 by mistake. My lords, kindly see page 37. It says COC decision must reflect the fact that it has taken on account the maximum value of the assets of corporate debtor and the fact that it adequately balances the interest of all shareholders, including operational creditors, my lords. This being the case, judicial review of the adjudicating authority that the resolution plan as approved by the COC has met the requirement referred to in section 30 clause 2 would include judicial review, that is to mention section 30 clause 2E as a provision of the code for the provision of law for the time being in force. If the adjudicating authority finds on the given set of facts that the foresaid parameter have not been kept in view, it may send resolution plan back to the COC to resubmit such plan after its satisfaction, my lords.
This is the inquiry we showed you at para 16, that it has to be in accordance with law.
Yes, my lord.
Which means you should not be given less than the liquidation value, which is what in para 16 you found, as brother read, liquidation value is so and so. You have been given above that. So it is in accordance with law being an operational credit.
But my lords, then there'll be a tax evasion cases multiply, like such as this, my lords. They filed a writ petition.
Dismissed. Next matter.
Let's, our relationship goes far. And please see what kind of an application of 23 was filed and recorded in Millards, and on which the execution is being sought today, Millards. If I may take your lordships to the application which they were filed at page 66, para 12, Millards, P12, Millards, annex. I'm so sorry, Millards.
Yeah.
Application compromise P10, I'm so sorry, Millards. P10 is the application, if your lordship would kindly come to. The second para, defendant being satisfied with the terms of dissolution of the partnership from above named dissolution annexer so-and-so application bearing no further will undertakes. Now, what is the undertaking, Millards, that they are claiming? Not to come within a radius of 500 meters of residence of so-and-so particular place. The second part, Millards, or any other subsequent residence accommodation plaintiff not known where. Now, second part, not to come within a radius of 500 meters of the workplace of a plaintiff at so-and-so place, and the house of parent at so-and-so place, and the brother at so-and-so place identified. Now, please see the remaining part. Not to commit.
Yes, by object. Courts have said
They have not yet decided the issue of executability.
within the decree, you undertook a compromise not to go near reminder, not to abuse, not to use foul language. And now if you are violating it, he is executing it.
I understand.
How you can object in a compromise decree?
No, had there been,
What can Supreme Court do?
let me assume for the time being this had been, because this still remains to be a contract. Now, can this kind of a contract at all be executable, Millards? Your lordship, that time and again held that this kind of a even if it's a compromise decree, it still has a scope of, it has to meet the qualification of a contract, Millards. Order 23.
Neutralize a compromise decree.
Millards,
This is a contract between the parties.
it's a contract.
With the court seal super added to it.
Yes.
It can only be set aside in a manner a contract can be set aside.
Agreed, Millards.
So now in execution, he said he's going, can you object?
Now the question is, Millards, had the initial decretal court gone into this validity of the question? Millards would kindly just come to the order passed by the
Sir, you have absolutely no case. Dismissed. Next
Millards,
matter.
kindly,
Dismissed.
Millards,
Next
because
matter.
this kind of an
Don't
agreement,
bring-
Millards,
don't bring
how can
such
this can be
litigation.
executed, Millards? At least
You
on the
want us to explain how it can be executed?
Millards, may
Should we
no,
explain?
I'm so sorry, Millards. May I only?
We'll end up in difficulty.
I'm so sorry, Millards. May I only request for one thing, Millards? 50,000 cost has been imposed for taking.
It should have been actually 5 lakhs.
Millards.
5 lakhs.
Millards,
Next
that would
matter.
be too unreasonable. Millards, may kindly consider
No,
that at least.
No, next matter. No. You take a consent decree and then you say, oh, it is not a valid decree, and you show us the contract act. Next matter. Next matter.
That issue has not been satisfied by the court below, Millards. None of the courts have looked.
Next matter.
Please, my lords. My lord, respondent is my overseas service provider, my lords. My lord, I have already paid the fees and bonus on the basis of the audited, accounted or annual accorded premium, my lords. My lord, which is net of discount, my lords. Now, my lord's issue arose, he said that you have given a discount of 69%, but you have to pay me my fees and the bonus as per the standard premium rate of the insurance policies, my lords. Whereas, my lords, whatever I am getting the money in my accounts, I am a public sector company, my lord, I have to pay this on that basis. Now, my lords, I want to point out one thing, my lord.
So what is the error in this?
Please, my lord, the honorable arbitrator has taken into consideration the tender document to arrive at its reasoning, not the agreement, my lords.
This you said in 34.
This we said in 34.
34 finished.
Please, my lords.
Same thing you said in 37.
My lords, the only,
Now you are here.
my lords, the only issue is this, the
Let's
annual,
Next matter.
delay may be condoned, my lords.
Next
My
matter.
lords, the annual audited premium has not been defined under the contract, my lord.
Next matter.
Obliged.
Well, it is the breach of the order under Order 39 Rule 2A,
Whose order?
High Court's order.
What did the High Court say?
Well, it is at page 42. Suit was dismissed, appeal was dismissed, and second appeal, the status quo order was passed against the respondents. And thereafter, on 31st of August, the property was sold to me. I am the petitioner purchaser. And in the sale deed, it is mentioned that there is no legal order. And I purchased, and court has punished me as well, along with the others who were the party to the litigation. Sale deed is also declared non-est, punishment is also awarded. And while I was not a party to the litigation, and I was not aware, and court has also not come to the conclusion that I was also aware. I am the purchaser.
Your respondent number?
I was not respondent in the.
You were not a party?
I was not a party in second appeal, in which the order was passed.
So which is that part of the order which, according to you, hurts you?
My lord, it is
Come to para 15, 1-5.
1-5, my lord.
Indisputably, there was an order of temporary injunction
My lord.
dated 27th of April 2016, right?
Yes, my lord.
Respondents 1 and 2, they have executed the sale deed, it also not in dispute.
Not in dispute.
It is executed in favor of numbers 3 and 4.
Who are the petitioners herein?
Right.
My lord.
So why do you say?
But I was not the party to that litigation in which injunction was granted. I am the party to the litigation which is.
Okay.
My lord.
Come at para 16.
My lord. Therefore, it is held that the sale deed dated 31 August 16, which was executed by respondent number 1 and 2 in favor of respondent number 3 and 4.
You are not being punished. The property which you purchased through 1 and 2 is ordered to be attached.
It is non-est, my lord.
Correct.
And then further, my lord. Further, my lord. It is directed in case if any mutation has been
So who
done.
is to be sent to the civil prison? 1 and 2.
Petitioners as well, my lord.
No?
My lord,
Come to para 20. Come to para 20.
My lord, the manner in which the respondent 1 and 2 has violated the temporary injunction order dated so and so, it is clear that they have done deliberately by showing complete disregard to the law of the land. As already held, the high-handedness of the respondent would promote lawlessness in the society which is determined to the civil society. Accordingly, no leniency can be shown either to the respondent number 1 and 2 or to respondent number 3 and 4.
Beg your pardon?
Accordingly, no leniency can be shown either to the.
Correct.
My lord.
But who has to be sent to the civil prison?
Thereafter, my lord, para 22. Furthermore, it is clarified that the respondent 1 to 4 shall not alienate the create any third party right.
You shall not alienate.
I am not alienating, my lord. Any third party right in any property in any manner, either by themselves or through agent, attachment in force. It is made clear that in case if it is found that the respondent number 1 to 4 have no property other than the property in dispute, they shall be sent to civil jail for a period of 3 months.
You agreed before the High Court. Rohit Bansal appeared on your behalf, counterpart.
Pardon me?
Your counterpart in the High Court was Mr. Rohit Bansal, advocate. He said he is prepared to execute cancellation of this sale deed.
My lord.
And that he doesn't want this property.
Exactly.
I am the purchaser, my lord.
Like 3 and 4.
I am 3-4.
You said you will execute cancellation deed and that you are not able to find 1 and 2. Correct? So now they have all been summoned. You go tell the High Court that I will execute, I don't want this property.
My lord,
ask him to give me back.
I will not get the money back, my lord.
Then you have to, the matter is pending in the High Court, no?
You have to take it up with the persons from whom you purchased.
My lord.
Number 1 and 2.
I purchased.
Cross violation of the injunction. Transfer the property in your favor.
My lord.
We are not getting into the controversy whether you are aware of this injunction or not.
My lord.
You may be, you may not be. Fine. You need to tell the High Court, I am ready to pass an order, execute a relinquishment deed in favor of that original plaintiff, right? And you just give up your claim. That's all.
My lord, the question arises, who will refund my money, my lord?
For that, you have to file a suit for recovery of money against respondent numbers 1 and 2. Okay? Today, this entire.
There should be willful disobedience, my lord.
How do we make him understand?
It is what this honorable court has held, my lord.
Take down. This petition arises from the order passed by the High Court of Madhya Pradesh, dated 28th of August 2025, in miscellaneous civil case number 2694 of 2019, by which the miscellaneous civil case instituted by the respondents herein under the provisions of Order 39, Rule 2, capital A of the Civil Procedure Code.
39.
Order 39, Rule 2, capital A of the CPC came to be allowed, and appropriate directions have been issued by the High Court. Full point. Put it briefly, the petitioners herein claim to be the bona fide purchasers of the suit property one. The respondent herein, original plaintiff, obtained an order of interim injunction restraining respondents numbers 1 and 2 respectively before the High Court from alienating the suit property or creating any encumbrance over the same in any manner. The respondents numbers 1 and 2 before the High Court are said to have transferred the suit property in favor of the petitioners herein by way of a registered sale deed dated 31/8/2016 in gross violation of the order of injunction dated 27th of April 2016, passed in second appeal number 203 of 2016. Next, the aforesaid led to the proceedings under Order 39, Rule 2, capital A of Proceedings. Next, the High Court, while disposing of the Order 39, Rule 2A proceedings held as under paras 15, 16, 17, 18, 19, 20, up to 24. Right? Being dissatisfied with, in such circumstances referred to above, the petitioners are here before this court with the present petition. Heard Mr. Dash, the learned counsel, appearing for the petitioners. Good. It is not in dispute that there was an order of temporary injunction passed by the High Court during the pendency of the second appeal. This order of temporary injunction is dated 27th of April 2016. It is also not in dispute that while such interim injunction was in operation, the suit property came to be transferred by way of a registered sale deed dated 31/8/2016. We do not want to enter into the controversy whether the petitioners herein are bona fide purchasers of the suit property for value without notice or not. We are with the High Court when it says that the entire transaction between the respondent numbers 1 and 2 on one hand and the respondents numbers 3 and 4 on the other could be said to be in gross violation of the order of injunction. First off, the High Court has rightly declared the entire transaction as non-asked and has ordered attachment of the suit property. We see no good ground to interfere with the order of the High Court. However, it shall be open for the petitioners herein to tell the High Court that they are ready and willing to execute a cancellation deed and restore the status quo ante insofar as the suit property is concerned. If such,
They are also at liberty to return to consideration.
it shall be open for the petitioners to also request the High Court to pass an appropriate order directing the respondents 1 and 2 before the High Court to refund the entire sale consideration. Okay, that's all. With the aforesaid, this petition stands disposed of. Next panel.
This will take care of your interest about. That's all you are interested in?
Pardon me?
That is all you are interested in?
Yes, madam.
That is if you are not colluding.
I was not knowing, my lord, anything.
What is the sale consideration paid by you?
My lord, at that time it was 9 lakhs,
In 16?
16.
When did you come to know about
When this notice came to me,
this notice
my lord,
from the court?
from of 39(2)(a), breach of the order.
The proceedings are of which year?
16, my lord.
And the notice came in which year?
My lord, this application was filed in 19, after 3 years.
Order 39, Rule 2A.
Yes, my lord. It is filed on 22/10/19. And I was not aware. I am completely bona fide purchaser.
You must have taken up this issue with the original owners who executed the sale deed.
My lord, now I am left with no option except to.
You are left with no.
They are very poor persons, my lord.
You are in collusion.
It is
the persons who violated the order of the court.
My lord, that
You have to pay the price for it.
I will certainly.
You have to pay the price for it.
But I was a bona fide purchaser. I was not knowing about the order.
I will not say anything.
This liberty is only on the facts of this case. Otherwise, you have to file a suit.
And get back your sale consideration.
Now you go make a request there.
As your lordship.
Lordship, we had submitted an adjournment letter in this matter.
What is this matter?
Lordship, it pertains to some Madhya Pradesh value-added tax act.
Chalo, adjourn.
Oblige, your Lordship.
My lord. In this matter, my lord, a question arises whether an oral exchange of the property, particularly in the state of Punjab, my lord, where one part of the property, my lord, is exchanged by way of a registered sale deed, whether then a registered document is required for the second part of the transaction, my lord. What happens is, I am the defendant.
Concurrent findings of.
I bow down. But my lord, I'll submit there's a question of law which arises. Your lordships, my lord, in 2021 had issued notice in such a matter, but the matter was finally disposed of without finally considering this question. If I may just hand over for your lordship's consideration.
Can you come to para 12?
Yes, my lord. That's the paragraph in issue.
Now, just read this para 12.
Yes.
And more particularly the last 4 lines.
Yes, my lord. Indeed. In fact, that's where I wanted to take your lordships also.
Right. Read it.
Just a moment. I'll read the para, my lord. Through the plea of oral exchange, I'm so sorry. Though the plea of oral exchange has not been raised as such in the written statement. I'll show your lordship the written statement. I deal with it. However, defendants in the WS specifically pleaded that they transferred commercial property in favor of Zile Singh on so-and-so, and the sale was without consideration. The said plea is against the recitals and contents of the document. Sale deed in question is a registered document. In order to rebut the presumption attached to recitals and statutory endorsement of the sale, appellants were required to lead positive
Evidence, none of the attesting witnesses examined to prove that the sale deed was executed in favor of the plaintiff Zile Singh by the defendants without any consideration in lieu of the house in question.
Now stop.
Now.
Now stop here.
Yes.
Now read these last four.
Yes, my lord. That's exactly where I would submit, my lord, that a question arises. Once the parties appeared before the sub-registrar for registration of sale deed, what stopped them from executing exchange deed if the properties were being exchanged? This remains unanswered. My submission is that in the state of Punjab, your lordship, section 118 of the Transfer of Property Acts does not apply. There's a division bench judgment to that effect, holding that in the absence of provision of section 118, section 54 of the Transfer of Property Act also does not apply. May I just show that to your lordships?
Yes.
I'll hand it over. Yes. This is my lord. Just give it to me. And this is my lord Sardara Singh and another versus Harbhajan Singh and others. My lord has it at page 54.
Yes.
Page 57, if my lord comes to straight away. My lord has it, para 9. It will be seen from this section that the act.
What is it? And then say, even if you take it as a
May I take your lordships through it? Para 9.
yes.
It will be seen from this section that the Act does not apply to the state of Punjab. However, by notification in this official gazette, a state government can extend the whole or any part of the Act to its territories. Similarly, a state government has been given power to exempt by notification, either retrospectively or prospectively, any part of the territories administered by such state government from all or any of the following provisions of the Act, namely Section 54, para so-and-so, 59, 117 and 123.
Ms. Kaju,
My lord.
we read para 12, right?
My lord.
Come to para 11.
My lord.
See, your clients,
My lord.
they claim to be the owners in possession of the suit property.
Yes, my lord.
Your first plea was that we have become owners by way of adverse possession.
My lord. My lord. My lord, the WS I would submit.
You will have to accept this.
My lord,
just a minute.
Please.
Trying to understand.
Please, please.
Now, at the same time,
my lord,
Paras Ram, he said that he had entered into possession of the suit property with the permission of Zile Singh.
In exchange, my lord. My lord.
Then the High Court says mere long possession does not graduate into ownership being adverse possession.
Yes, my lord.
Until and unless the party claiming to be in adverse possession is able to show the date on which his possession, we are not concerned.
My lord.
Paras Ram admitted to be in permissive possession, and there is no date on which the possession became hostile. Now, once you bring the case of exchange,
my lord,
right, your plea of adverse possession fails into insignificance. Wait a minute, wait a minute.
I'll go with your lord.
Perhaps you may have some case. So forget about that adverse possession.
Very well.
Now come to para 12.
My lord.
You take us to your written statement.
Yes.
And point out where have you said about this oral exchange?
Yes, my lord. I'll just take your lordships there. My lord may come to annexure P2. Page? That's at page 112. Where's that?
P2.
Yes, my lord. P2 is the WS.
Which is the relevant paragraph?
Now, my lord, I'll just show you as far as the plea of adverse possession is concerned, we say that we have become owners of the house in question by way of adverse possession also. And then my lord may come to page 114. Where I set out the. Now, my lord, in 114, I show that where my possession begins, and then 115, my lord may see.
No, take us to.
Yes, 115. In fact, the fourth line from the top. Fourth line from the top. Shall I continue?
Your matter is safe so far. Something.
So far may be the operative words. In fact, defendant number 1, fourth line from the top, gave commercial plot for the purpose of constructing 2 proposed shops in the area of so-and-so to the plaintiff Zile Singh, read sale deed number so-and-so. And in fact,
Sale deed?
Yes.
Who executed the sale deed?
Zile Singh, my lord.
In your favor?
No, my lord. I'm sorry. It is executed by us in favor of Zile Singh.
Correct.
Yes, we transfer that, my lord, and our case is by so-and-so. Now, since this said, and no consideration was paid to the defendant number 1 by the plaintiff. Since the said plot of so-and-so, commercial plot was not in the name of defendant number 2, hence, civil court collusive decree could not be executed past for formalities purpose. The sale deed was executed.
Which they execute.
The exchange. Sale deed,
my lord.
Sale deed must reflect the exchange.
My lord.
Or Ms. Tarju, assuming
Yes.
this law of registration,
Yes.
Transfer of Property Act, 118, etc., inapplicability is correct.
Yes.
It doesn't foreclose having a document for exchange.
Now, may I submit? Now, your lordships may turn to page 51 of my compilation. This is the very question which arose before your lordships. Notice was issued, but the question was left unanswered. May I submit?
If your case is,
My lord.
exchange was in consideration
My lord.
of the sale.
My lord.
The deed must say that.
My lord, so may I then pause it? And that is the.
One more question.
Please.
Pauses the case.
In the sale deed,
My lord.
which y'all executed in favor of Zile Singh,
My lord.
there is no sale consideration.
My lord, that's the case. Otherwise, I can bring that document before your lordship. But if I can just show your lordships page 51.
Brother pointed
Yes.
out to you.
Yes, that's the case also, my lord, in the WS. May I just point out page 51 from the compilation for the sake of completeness to your lordships?
Oral exchange.
My lord, so in fact, in this case, then a question will arise.
You are saying that the oral exchange is
Yes.
pegged as consideration.
Yes.
A sale deed.
Yes.
The normal question will be,
Yes.
sale deed reflect that?
Yes.
Or do you have any other document?
Indeed.
Leave by the second part. It must reflect.
Indeed, but your lordships, that is where I would humbly submit that there's a question which arises for your lordships to answer. And the reason that this is not done by the High Court, my lord, in second appeal is that section 41 of the Punjab Courts Act states that no question of law is required to be.
That is settled by constitutional.
Yes, I bow down. So therefore, my lords may just turn to page 51 of the compilation, if I may read.
Finding of fact.
My lord.
3 courts.
My lord.
None of the attesting witnesses was examined by you.
My lord.
To prove the sale deed executed in favor of the plaintiff Zile Singh by you without any consideration. That's it. Once the parties appeared before sub-registrar for registration.
My lord.
What stopped them from executing an
Yes, my lord, but I would submit, my lord, where the law does not require, I mean, if I'm just for the sake of completeness, where the law does not require registration of a document.
Fine. For the time being, we are with you.
My lord.
Law exempts you.
Yes, my lord.
Show us on facts.
My lord, once the law does not require the registration of a document, then for the High Court to say that I ought to have registered a document.
Not dispensed with evidence.
My lord.
Must be there.
Yes, my lord. So I set up the case of oral exchange, my lord, and I also say that the timeline shows that the deed is executed, my lord, for the commercial property, and 25 days later I come into possession, my lord. And from 93 onwards, I show my possession. It's only in 2008 that they come forward, my lord, to say that I was a licensee at the time of the wedding of my daughter, and therefore my license was only for a limited period. But 51 in two in 21, your lordships issued notice on this very question, my lord, on section 118 as it's applicable to Punjab. But all I'll submit is on the limited question of law, your lordships may consider issuing notice. Otherwise, my lord, it's also a case where mandatory injunction has been sought without any relief of possession. And my lord, far beyond limitation. And secondly, my lord, I'll just make one more submission before your lordships. The trial court, my lord, looks at the evidence of the expert witness on the question of thumb impressions, and then, my lord, disregards it to examine the thumb impressions itself. My lord, I'll submit that there, my lord, the trial court could not have substituted its own opinion for the opinion of the expert.
Okay.
I'm obliged.
Thank
I'm obliged.
May I please?
Would your lordships consider issuing limited notice on the question of mediation if parties could be sent? It's a family matter at the end of the day. I'm obliged.
Lordship's last order had indicated
Lord,
that.
before my learned friend begins,
No,
I,
just drawing the last order.
no, just a minute. My Lord, I have a request to make. I'm appearing on behalf of the respondents. I'm ready and willing to go ahead with the matter. However, since this matter concerns my giving you details about child sexual abuse, I'm only requesting that the matter would be in camera in as much as we can continue in the courtroom. This is my request. But my lord, the courtroom may be cleared of people who are not concerned with this case. That's my only request. That's my only request. My lord, I don't feel comfortable talking about child sexual abuse in the presence of strangers. You're supporting my application. It should be in camera.
In fact, my lord,
Well, that's my limited request. I'm happy to go on with the matter. I'm prepared.
The last occasion my lordship had directed me, did you interact with the child? In fact, I hosted the child for the entire day in my home without the presence of the mother. She was with us, played with the whole day. I want to assist my lordship as a counsel for the child. I want to appeal to my lordship's conscience and leave it at.
Well, Lord, I'm sorry, but we need to take a decided call on this issue.
We are discussing something else.
I'm sorry, my lord, excuse me.
He's asking in camera.
'Lordships had recorded. Wait.
September 2020. Our order dated 8th of September 2025 reads thus. Good. We take notice of the fact that last year, this court which one of us, K.V. Vishwanathan J., was a part of the bench, had the occasion to interact with some parties, including the minor girl.
On 1/10/24.
Yes, please.
The record reveals that the interaction had taken place on 1st of October 2024. Almost a period of 1 year has elapsed. We are of the view that we should have one more round of interaction with the parties. We direct the parties to personally remain present on.
If I may make a request, Malad.
On 16th of October at 2 p.m. We shall talk to the parties in the committee room.
And counsel. That will take care of your prayer.
My lord, I'll be obliged.
We request the parties to keep the minor girl also present on that day. Also, okay? That's it.
Lordship, the father did not get to interact also with the child for more than a year. Lordship would just bear this in mind. 31st March.
Wait till 16th of October.
Very well, my lords.
Obliged.
I have a list of dates. May I just hand that over?
Yes.
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 Because I'll just take a little while on the parties because the names are all rather similar. So the appellant whom I represent the name is Gloucester Limited, and it is a successful resolution applicant or SRA. So this is arising from IBC. Respondent number 1, Gloucester Cables Limited, is an associate company of respondent number 2. Respondent number 2, that is Fort Gloucester Industries Limited or FGIL in this list of dates, is the corporate debtor who has undergone a resolution. And respondent number 3 is the erstwhile resolution professional. So these are the parties. At one point of time, historically, it was the Bangur family who owned these various, and that's why you will find that this Gloucester is being used everywhere. I might just by way of introduction mention what the controversies, and then I'll read on with the rest of the list of dates. There is a very valuable trademark, Gloucester, in the context of in relation to electric cables, which now are being manufactured by us. We, the appellant, having being the successful resolution applicant in respect to the corporate debtor FGIL. So now we have it. The trademark obviously came along with, according to us, with the company when we bid for the resolution process. Now the whole thing went through, and the resolution process has been sustained all the way up to this court, and we are completely in harness, so there's no problem at all. An application was, however, made, and the application was to the effect that, look, this particular trademark Gloucester had actually moved out from the assets of the company, and it vested, and this was in a sister concern prior to the date of the moratorium, etc., kicking in. The NCLT was pleased to reject this claim. However, the NCLAT has reversed, which is why we're here before the court. So this is broadly the issue.
One clarification.
Yes.
You are Gloucester Limited.
I'm Gloucester Limited.
Before getting into this CIRP and being successful resolution applicant,
Yes.
what were you doing?
Jute. I was in the business of manufacturing jute.
You have nothing to do with cables.
No, I at that point of time did. Right. But this company did.
Correct.
Yeah.
So you are not in the business of cables.
Now I am, but not then.
Taking over.
Yes, correct. Absolutely right.
Now, since you are taking over Port Gloucester Industries,
Port Gloucester, correct.
which is an associate of Gloucester Cables Limited, you want that this name Gloucester, this trademark Gloucester, should come to you.
No, so it's common ground that the owner of the mark was the company which was the corporate debtor, which is R2 Fort Gloucester.
Correct.
Okay, that's an admitted position. The question is that let's keep all this. If ordinarily the corporate debtor, which has undergone resolution process, I have bought in and I am now running the successful resolution applicant, all assets of that corporate debtor would vest in me. I mean, that's the usual process, correct? That's the whole idea of resolution process. Now, what is being suggested by the contesting party is that this asset, which historically it's admitted belonged to the corporate debtor, at some point moved out of the corporate debtor and vested in an associate company, which now makes a claim with regard to this valuable trademark. That's where we are.
Which is that company?
That is respondent number 1, Gloucester Cables Limited, is an associate company.
So, according to Gloucester Cables, at one point of time,
yes,
it was an associate company of R2.
Yeah, that's not in dispute.
Later,
No, it's not in dispute.
it severed the relations.
No, it didn't sever, etc. But severance, they had a relationship. That relationship continued, and they had the advantage, according to them, of this particular trademark being assigned to them. So they say that now I'm the owner of this particular valuable trademark.
So even after taking over Port Gloucester Industries Limited,
yeah,
and you being Gloucester Limited,
yeah,
you will not be able to carry on business in the name of Gloucester Cables Limited.
Yeah, I won't be able to use that trademark unless I succeed.
You are already Gloucester.
I am Gloucester. So we are talking about a trademark in relation to registered trademark that will come.
That registered trademark
Class 9.
Gloucester Cables Limited, right? You have a name Gloucester.
Yes, yes.
Nobody is taking away that name.
Yeah, yeah.
You can still continue with the business of this respondent number 2 in the name of Gloucester Limited.
No, but I can't use the mark qua electric cables unless I am the owner of the trademark.
So
it's a very well established trademark. Sorry.
Now you want what name? What type of name?
Sorry, Jasmine. I didn't hear that last one. I'll just explain it, Manoj.
You are Gloucester Limited.
It will become very clear, Manoj. I'll read 3 more paragraphs. I'll just indicate what it is. It's Gloucester, sorry.
You continue. Only thing is that case appears to be R1 Gloucester Cables, correct? Claims that the trademark Gloucester,
Yes, is now with them.
assigned to it.
Correct.
So notwithstanding the approval of the plant and you are coming in as the SRA,
Yeah,
You can't use Gloucester.
absolutely correct.
Now, this they ask in a section 60 subsection 5 application.
Yes, correct.
Is it in relation to insolvency post the approval, or is it a title suit?
No, so they've got a separate title suit.
That's going on.
Yeah, well, yes, there's a separate title suit which they have.
Post approval in May, they filed this application.
Yeah.
What is there any argument on maintainability of this application here to decide this issue? Ordinarily, what will happen? You take the approval, you're gone.
Yeah.
You have approved the plan, the new management has come in.
Yeah.
You are assumed that you are using the Gloucester in your cables.
Yes.
He says, I am the owner, I have this assignment.
Right.
He will file an infringement action if it is registered
So
or
that can
passing
be
of a-
decided.
How does the NCLT get jurisdiction post approval?
So what he did was he first in point of time moved the NCLT and essentially said that, look, I have given documentation to show that there is already an assignment in my favor and therefore this should not be part of the resolution plan.
When did he say that?
He said that prior to the execution of, prior to the approval of the resolution plan. Yeah, so I am going to take, because there was collusion over here, which I'll have to explain that. There was collusion over here, and I'll just indicate to your lordships as to, 2-3 points. So for the first point which your lordship may note is that as far as the moratorium is concerned, which comes in under section 14(1)(b).
You will take about half an hour?
No, I'll take a little longer than that, Manoj. I don't.
Matters in the second session.
Yeah,
Rest
I'm
of
grateful.
the matters in the second session.
I'm grateful. So, sorry. So, can I just state the main point and then I'll go through the list of dates, because it's a little involved. The first point, which I'm just for your lordship's consideration, is that the moratorium comes into effect on 9th of August 2018. And you can have no effect, 9th of August 2018, and you can have no alienation of assets after the moratorium. That's my first point. My second point is that the only way the law recognizes an assignment of trademarks is through a registered agreement in terms of section 45 of the Trademarks Act, and absent a registered agreement before 9th August 2018, the asset remained with the corporate debtor, that is Fort Gloucester. The third element which I will show you is, it appears to us at least that there is complete collusion over here between two associate entities in trying to take away a valuable asset, and that ought not to be countenanced. Now, my lords, may I just proceed with the list of dates?
Yes.
So, para 5, the appellant, which is Gloucester Limited or GL, has filed the present civil appeal against the impugned order dated 4th January 2025, passed by the National Company Law Appellate Tribunal. By way of the impugned order, GCL's limited appeal filed against the order dated 27th September 2019, passed by the National Company Law Tribunal, was allowed. The short dispute in the present proceedings relates to the ownership of the trademark Gloucester, which is a registered trademark under Class 9 in relation to electric cables and wires bearing registration number 690772. It is R1 GL's case that the said trademark was owned by R2, which is Fort Gloucester, and consequently, under the resolution plan approved by NCLT, Gloucester Limited acquired FGIL along with the said trademark. On the contrary, the respondent's case is that the said trademark stood assigned to GCL, an associate company of FGIL. This assignment took place by executing two agreements. One, a supplemental trademark agreement dated 15th July 2008, and two, a deed of assignment dated 20th September 2017.
Just one correction.
Yes, sorry.
Para 6. It is appellant's case perhaps.
Yes, I think so.
Para 6. Para 6.
Yes, Manoj, it is not R1.
Appellant's case, no?
Yes, my mistake.
Yeah, yes.
The third line in para 6. On the contrary, the respondent's case is that the trademark stood assigned to GCL, an associate company of Fort Gloucester. This assignment took place by executing two agreements, a supplemental agreement of 15th July 2008 and a deed of assignment dated 20th September 2017. Therefore, the trademark is an asset of GCL and not FGIL. While NCLT rejected the case of GCL, the NCLAT on appeal has, without considering the relevant facts and documents, reversed the ruling of NCLT and held that the trademark Gloucester is an asset of GCL. Now, just the dates: 1890, 1950. FGIL was incorporated in 1890. Sometime in 1958. Sorry. Oh, sorry.
Yes.
Sorry. First, I was on the first serial number. There are two dates, 1890 and 1950. So the company FGIL was incorporated in 1890. And sometime in 1958, FGIL set up a plant for manufacturing electrical and power cables and began selling the product under the brand name Gloucester. The term Gloucester originates from the place Fort Gloucester in Howrah, which is where FGIL's manufacturing plant is located. In 1995, FGIL, being the proprietor of the trademark Gloucester, got the same registered under registration number so-and-so under class 9 in relation to electric cables and wires under the Trademarks Act. In 1995, the promoters of FGIL, along with certain third parties, incorporated GCL for carrying on the business of manufacturing electrical wires and cables, being the same product manufactured by FGIL. On 2nd May 1995, FGIL and GCL entered into a technical collaboration agreement whereunder FGIL provided license to GCL to use its trademark Gloucester for a period of 8 years. On 10th September 2001, BIFR declared GCL as a Sikh industrial company under SICA. In terms of the order, the company promoters were directed under Section 22A of SICA not to dispose of any fixed or current assets without the consent of the secured creditor. So this was the BIFR order, which was a standard order. Now, let's agreements entered into between respondent number 1, GCL, and Fort Gloucester. Fort Gloucester, in 2003, Fort Gloucester suspended its cable manufacturing activities. On 29th July 2004, a license agreement was executed by FGIL in favor of GCL, granting the latter an exclusive non-transferable license to GCL to use the trademark Gloucester for a period of 33 years, extendable to 99 years, for a one-time consideration of rupees 3 crores and an annual royalty of rupees 2 lakhs. On 10th November 2006, a loan agreement was executed by GCL in favor of FGIL, granting a loan of rupees 10 crores to FGIL. This loan was secured by a first and exclusive charge over the trademark Gloucester. On 31st January 2008, pursuant to the loan agreement, a memorandum of hypothecation was executed by FGIL, creating a charge over the trademark Gloucester in favor of GCL. On 15 July 2008, it is the case of GCL that a supplemental trademark agreement was executed between GCL and FGIL, whereby FGIL assigned the trademark Gloucester to GCL for a consideration of rupees 10 lakhs, which seemingly had been paid to GCL by FGIL. Because we'll refer to clause 1. This is the supplemental agreement. This agreement records that the assignment shall become effective without any further act or deed after vacation of the order passed by BIFR, because BIFR had otherwise granted an injunction and a restraint order. Note, it is the appellant's case that this is a fabricated document manufactured after commencement of CIRP of Fort Gloucester with the intent to retain the trademark Gloucester. This is evident from A. This agreement is not reflected in any of the financial statements of FGIL. Even the financial statement of GCL as on 31st March 2009 does not reflect execution of this agreement nor payment of rupees 10 lakhs. Lenders of FGIL were never aware of this agreement was executed by FGIL. During the pendency of proceedings before BIFR, FGIL clearly represented that it continues to be the owner of the trademark Gloucester and that the trademark had only been licensed to GCL, and this is recorded in the BIFR order dated 2nd March 2010 and 16th March 2012, on the assumption that this agreement was in existence since 15 July 2008, and both GCL and FGIL proceeded on the basis that the agreement came into effect on 1st December 2016. That's the date on which the BIFR order was vacated. There was no occasion for GCL to pay license fee of rupees 2 lakhs to FGIL for the financial years 2017 to 2018. Dear Lords, is this reasonably clear? This point which we are making in serial number E. Obviously, the transfer did not take place because, had the transfer taken place, the point being made in subclause E on page 3 is that had this transfer taken place, there was no occasion to pay the license fee because there was no question of the license at all.
Now come back to the previous page.
Yes, previous page.
Back to entry 10.
Entry 10, yes, please.
Before your note.
Yes, yes.
Now read that again.
I'll place it. It's the case of GCL that a supplemental trademark agreement was executed between GCL and FGIL, whereby FGIL assigned the trademark Gloucester to GCL for consideration of rupees 10 lakhs, which seemingly has been paid to GCL by FGIL.
Now,
yes, sorry.
The next 3 lines.
This agreement records that the agreement shall become effective without any further act or deed after vacation of the order passed by BIFR.
What has the 22A order got to do? Because that order is to restrain alienation of GCL's assets.
Yes.
This is alienation of other way around. FCIL is giving into GCL.
22A was against FGIL.
You see, 22A, the old SICA 22A.
Yes. Oh gosh, well, there's a mistake we made.
There's an error perhaps in.
Yeah, there's an error. There's an error.
It should be. It's for Gloucester.
Well, that's a mistake at serial number 5.
10.
The SICA order.
Order is right. SICA order would have said.
No, it's BIFR declared FGIL.
Oh, FGIL.
Yes, it's our mistake. I'm sorry.
Oh, now it makes sense.
Yes, I'm so sorry, Manoj. I apologize. Manoj, I was on small clause E on page 3.
Yes.
On the assumption that this agreement was in existence since 15 July 2008, and both GCL and FGIL proceeded on the basis that the agreement came into effect on 1st December 2016. That's the date when the BIFR order was vacated. There was no occasion for GCL to pay a license fee of rupees 2 lakhs to FGIL in the financial year 17 and 18. So the fact that they paid the license fee is an indicator as to who the licensor was, even in 2017 and 2018. Even otherwise, the alleged assignment under the supplemental agreement is ex facie undervalued, as the trademark Gloucester had been hypothecated by FGIL for a loan of INR 10 crores. To overcome the above objections, GCL, by way of an application for additional documents filed before this honorable court, has now sought to introduce evidence of the following documents, which, my lords, we are resisting, but I will read this in any case. A board resolution dated 30th April 2018, passed by FGIL for executing the supplemental trademark agreement with GCL. Emails exchanged between the counsel then representing GCL and one R.C. Kalani from Jaishree Chemicals. It is the case of GCL that the draft of the supplemental agreement was exchanged between GCL and FGIL during the contemporaneous period. Bank account statement of GCL reflecting payment of INR 10 lakhs in favor of FGIL on 16th July 2008. GL objects to the production of these documents at this stage of the proceedings for the following reasons, and a reply to the same has been filed, though no notice has been issued on their application for additional documents. The only reason pleaded in the application for production of the documents at this stage is that GL has made out a fresh case on fraud. As elaborated in the reply to IA 93134, each of the arguments raised by Gloucester Limited, that's myself, in the present appeal have been specifically pleaded before NCLT and the NCLAT, and B, none of the conditions set out in Order 47, Rule 27 of the CPC are satisfied in the present case, for the reason that GCL had ample opportunity to produce the documents before NCLT and NCLAT. Sufficient reasons have not been provided by GCL warranting admission of the documents. GCL is now producing these documents only to fill a lacuna in its case, which is not permissible. GCL has nowhere pleaded that the documents could not have been produced by it before NCLT and NCLAT, in spite of exercising due diligence. In the above background, the very genuineness of these documents is questionable. Now, SICA comes to be repealed on 1st December 2016. Now, on 20th September 2017, it's the case of GCL that a deed of assignment was executed between GCL and FGIL, recording as follows. In terms of the supplemental agreement, the trademark Gloucester stood assigned to GCL with effect from 28th May 2017. GCL has approached FGIL to execute the assignment deed to enable recording of the assignment before the trademark registry. As and when the assignment is recorded with the trademark registry and the name of GCL is entered in the subsequent owner proprietor of the trademark, the license agreement shall stand terminated. This agreement was manufactured fraudulently, that's my case, after commencement of CIRP by the promoters of FGIL with the intent to retain the trademark Gloucester through its related party, GCL.
Just a minute.
Yes, I'm sorry.
brother also has this doubt.
Correct.
15/7/2008 supplement agreement. We'll keep aside your argument on fabrication.
Yeah, keep that aside. Keep that
Now,
aside.
for 15/7/2008 is the supplement agreement which is to be effective after the VAFR order is vacated.
Correct.
The order itself is vacated later.
Of 1/12/2016.
And now you have dealt, you have shown us this agreement now.
Yes.
That is
Serial number 12.
serial number 12.
Yeah.
Deed of assignment.
Yes.
Recording that it will be effective from some date.
Yeah.
2015 date, I think. Anyway, any of these are registered?
So now that's the most important question. So that's one of the very interesting stories. So I don't want to, I mean, like a movie script, I don't want to reveal what happened. So anyway, since your Lordship has asked me this question, let me just tell you. What happened was that without the IRP, or the RP knowing about it, the same lawyer representing both sides got the document registered subsequent to commencement of the CIRP process. So that's going to be my point, that registration is mandatory. It never happened prior to the commencement of CIRP. And what they did was they withheld all these documents. They withheld it not only because these huge valuable documents were not disclosed to the financial creditors, etc. So nobody in the COC knew about it. And just at the 11th hour, when the matter is going up before the NCLT for the purposes of approval of the plan, etc., at that time, these documents are produced by the former promoters to say that, oh, all this is assigned, etc. Anyway, I will place that before you also. But that comes out in this list of dates. So to answer your question, there was no registration at the point of time until after CIRP commenced, which is according to us, if we are right, fatal insofar as their claims are concerned, because you have to have a registration. The moment the moratorium kicks in, there's no question of registration. So that's the other dimension to the matter. And the stamp duty is also paid later, 2018. So I will just come to that. So now let's just go to the top of page 5. Top of page 5, if your Lordships would. So these are short comments on the 20th September 2017 assignment deed. The agreement is not reflected in any of the financial statements of FGIL. That's important. Lenders of FGIL were never aware of this agreement was executed by FGIL, and the additional stamp duty on the assignment deed was paid on 24th August 2018. That is during CIRP of FGIL and a year after execution of the alleged agreement.
With private funds, not the corporate debtors funds. Whose funds?
It wouldn't be the corporate debtors fund, but I'll just check up, your Lordship. I'll just check this up. Whose fund?
RP would have been.
Yeah, otherwise he would have known. Yeah, but he says that he doesn't know. He doesn't know. Now, please see commencement, my lords, of CIRP against FGIL.
Probably the assignee would have paid it.
Yeah, that's possible. Yes. Commencement of my lords, I'm on section C at the instance of one of its employees. So on 9th August 2018, serial number 13, a petition under section 9 of IBC filed against FGIL by one of its employees was admitted by NCLT, thereby commencing CIRP against FGIL. On 25th August 2018, an application was submitted by GCL through its attorney, depenning and depenning, to the Trademarks Registry for registration of the assignment deed to have GCL recorded as the proprietor of the trademark cluster. Your Lordship, that was your question, correct? So this is an important date, 25th August 2018. Now please see 4th September 2018. Depenning, that is the firm which had filed the application before the Trademark Registry on behalf of GCL, issued a letter on behalf of FGIL stating the latter's no objection to register the assignment of the trademark in favor of GCL. See, it has now commenced, my lords.
25/8 is admitted.
Correct. Yeah, and 9th August 2018, CIRP has commenced.
No, commenced on 25/8. No, when was it admitted?
No, 9th August.
9th August.
9th August, my lords, sorry, it's admitted by NCLT, thereby commencing CIRP. Your Lordships have that? Correct? Then you make on 25th August, there is an application submitted by GCL. through its attorney to the trademark registry for registration. Correct? That is depenning. Now see what happens on 4th September. I'm just reading it. Depenning, that is the firm which had filed the application before the trademark registry on behalf of GCL, issued a letter on behalf of FGIL stating latter's no objection to register the assignment of the trademark in favor of GCL. Now this is, according to us, collusive conduct. The attorney who had given the NOC on behalf of FGIL was also representing GCL, and the RP had not authorized the attorney to provide any NOC, nor had knowledge that such NOC had been provided on behalf of FGIL. And this is pleaded by the resolution professional at page 11 of his counter affidavit. This is very serious, my lords, very serious. Now, on 17 September 2018, the assignment of the trademark Gloucester was recorded in the name of GCL by the Registrar of Trademarks. The registration of the assignment was barred under section 14(1)(b) of the IBC as it amounted to transfer of one of the assets of FGIL. So this is the other point, very, very important. Moratorium had kicked in by now. 22nd September 2018, the information memorandum published by the resolution professional in accordance with section 29, the information memorandum included a balance sheet filed for the financial years 2017 to 2018 as of 31st March 2018, which revealed the following: that GCL paid a license fee of INR rupees 2 lakhs to FGIL during financial years 2017 to 2018. Your Lordship sees this license fee is being paid, which is completely inconsistent with any notion that you are the owner. An interest-free loan from GCL was secured by FGIL by hypothecation of the trademark Gloucester. So that's also revealed in the balance sheets. FGIL had not recognized value towards the trademark Gloucester in its books of account, as FGIL had borrowed money from GCL by way of exclusive charge over the trademark. Now our notes. The RP has specifically pleaded that the trademark Gloucester was included in the information memorandum as an asset in terms of section 29 of the IBC, read with regulation 36 of the CIRP regulations. The supplemental agreement and the assignment agreement were not disclosed in the information memorandum provided to all the resolution applicants. On the basis of the clear disclosures made in the balance sheet of FGIL, all stakeholders, including Gloucester Limited, proceeded on the basis that the trademark Gloucester was legally owned by FGIL. Though this fact has no bearing, the RP in its reply before this honorable court has pleaded that the erstwhile promoters of FGIL provided the aforesaid agreements to the RP on the 3rd or 4th of April 2019. Before the NCLAT, the RP had pleaded that the supplemental agreement and assignment deed were never provided to the RP until the resolution plans were put to vote before the COC, that is before 24th April 2019. Of course, I am not in the picture at this stage. On serial number 18, on 10th April 2019, there's a forensic audit report for FGIL was submitted by the forensic auditor appointed by the RP. As admitted by the RP, a copy of the supplemental agreement and the assignment deed were not placed before the auditor. A copy of the agreements were not provided to the resolution professional when the auditors were appointed. On 11th April 2019, the 5th meeting of the COC of FGIL was convened, wherein the forensic auditor stated that there was inadequate support for the KMP of FGIL, the key managerial persons. So there was inadequate support by the key managerial personnel of FGIL, as sufficient documents were not being provided by them. On 19th April 2019, Gloucester Limited submitted its final resolution plan with the RP. Insofar as a supplemental agreement and the assignment agreement are concerned, the resolution plan provides for the following. The resolution applicant believes that the said agreements have been entered into by FGIL with its related party GCL with the intention of transferring the said trademark to GCL with a malafide intention, although the said transfer was barred by law under SICA and is also barred under the IBBI during moratorium period. The corporate debtor entered into these agreements during the intervening period between the admission under IBBI and repeal of SICA. The resolution applicant therefore believes that the trademark Gloucester has been assigned and or transferred to GCL is bad in law. The resolution applicant understands that this trademark is the lawful property of the corporate debtor and the said trademark shall remain the absolute property of the corporate debtor post its acquisition by the resolution applicant. During the process of due...
Your bid was how much? How much did you pay?
74 crores.
74 crores, my lords, I understand. And then we had to invest to get the plant operational. We have invested a further 40 crores. But that's, of course, to get the whole thing up and running. During the process of due diligence carried out prior to the submission of the resolution plan, Gloucester Limited discovered that the registration of the trademark was fraudulently transferred by GCL in its favor on the basis of the aforesaid agreements. It is thus for this reason that the above recitals were included in Gloucester GL's resolution plan. GL's resolution plan was approved by COC under Section 34 with a majority of 73.21%. Pursuant to the approval of the resolution plan under Section 30, subsection 4 of IBC, on 1st May 2019, CA 584 of 2019 was filed by the RP before NCLT for approval. On 28th May 2019, during the pendency of the above referred application filed by the RP, an application under Section 60, subsection 5 of IBC was filed by GCL before NCLT, praying for a clarification that the trademark Gloucester is not included in the assets of FGIL. The application has been filed by GCL on the basis of an averment that by way of the supplemental agreement read with the assignment deed, the trademark Gloucester was assigned by FGIL to GCL with effect from 28th May 2017. GCL has further pleaded that subsequent to the above, GCL is registered as the subsequent proprietor of the trademark Gloucester with the trademark registry and hence enjoys exclusive statutory and proprietary rights to the trademark Gloucester. The application was filed without enclosing a copy of the above referred agreements. The said agreements were brought on record before NCLT only by way of GCL's rejoinder in response to the objections pleaded by Gloucester Limited. Though not stated in the application, GCL has the following trademarks registered in favor by the name of Gloucester. Registration number so-and-so, registered under class 9 of cables and wires and all kinds of all kinds, including class 9. Registration ending 2764, dated 31st July 2025, registered under class 9 for switches, MCB, RCCB and distribution boards. Registration ending 2775, dated 17/6/2020.
So right now you are not using this mark for cables.
We are using it. We are using it. Yes. And we've started now that the commercial, because the factory has been started, etc. The present dispute, however, is limited to the trademark Gloucester, which bears registration 0772 and had been registered in favor of FGIL since 1st January 1960. GCL has, however, tried to refer to the other trademarks referred to in Note 3 above to claim the right to exclusively use this trademark. In June 2019, separate replies were filed by the resolution professional COC and GL objecting to the application filed by GCL. By way of the application, the respective parties echoed that the supplemental agreement and the assignment agreement appear to have been manufactured with the intent to divest FGIL of the trademark Gloucester, which is a valuable asset of FGIL and is essential for resolution under IBC. The relevant financial statements of FGIL reflect that as the commencement of CIRP, the trademark Gloucester was an asset of FGIL. 27 September 2019, a common order was passed by NCLT allowing the application filed by the resolution professional under section 36 of IBC and dismissing the application filed by GCL. GCL's application was rejected with the following findings. GCL cannot claim any right over the trademark on the basis of agreements executed between FGIL and GCL between 2001 to 2006, as the said agreements were executed in violation of the BIFR order. The agreements executed in violation of court orders are void. The assignment deed is a preferential and an undervalued transaction, as it assigns a trademark valued at INR 10 crore in 2008 for INR rupees 10 lakhs. Filing of an application by the resolution professional under sections 43 of the 46 of the IBC is a procedural requirement. Since GCL approached the NCLT on the strength of agreements executed 2 years prior to the commencement of CIRP, NCLT can examine such documents in terms of sections 43 to 46 of the IBC. On 7th November 2019, a limited appeal was filed by GCL before NCLAT. Yes, I'm sorry. Whichever document you want to show. Okay. But this assignment, which conflict registered, is on that 8th. The registration of the assignment was part. So this was not submitted directly. And there was no cooperation. No, and when did it report from the
Report came on 10th April, but agreements according to the investigation provided on 4th April.
Not a finding about lack of registration. Or,
yes.
Or because there was a registration in the middle of the CER. Otherwise, your case is 2008 supplement agreement and the 2017 assignment deal are all got up documents. And actually what has happened is only a 2019 post-admission registration.
Correct, correct.
At the behest of depending without the involvement of the RP.
Correct, correct, absolutely.
Just to show consideration having, otherwise consideration if it is done now should come into the CD's account. So they showed a 2000, it's your case.
That's right.
10 lakhs was transferred and 2017 document was formalized, not registered. Registration happened only in 19. In the 18, in the meantime, license fees were also paid, you are saying.
Correct. Yes.
For a period post assignment.
Correct. Yes. Yes.
Despite the license will come to negative. Despite the second agreement will come to negative.
Did show, just keep double check this. Yep.
So in A, let's see the registration. Yeah. Agreement executed in violation of the Injunction order is not what.
Seems.
No, the first one, yes. This one talking. This is the main one. It's 6. Because I was just on serial number 26. There was a limited appeal which was filed by GCL before NCLAT, assailing rejection of its application by NCLT. GCL did not challenge the approval of the resolution plan by NCLT. During the pendency of the appeal before NCLAT, no interim order was granted in favor of GCL. Now, on 27th December 2019, an application under Order 39, Rule 1 and 2 of CPC in COS 43 of 2019 was preferred by GCL before the City Civil Court, Hyderabad, seeking an injunction against FGIL and GL from dealing with the trademark Gloucester. The said application was dismissed by the court on 27 December 2019, inter alia on the ground that the dispute qua the ownership of the trademark is the subject matter of proceedings before the NCLAT. An appeal was filed by GCL against the order dated 27 December 2019 before the High Court of Telangana, which was dismissed on 14th February 2022. An SLP preferred against the dismissal of the appeal by the High Court of Telangana was also dismissed by this Honorable Court on 22/7/2022. The civil suit filed by GCL is still pending before the Civil Court, Hyderabad. August 2020. Pursuant to payment of INR 72 crores approximately to all stakeholders, the resolution plan of GL was implemented and management of FGIL was handed over to Gloucester Limited. Steps taken by Gloucester Limited taking over the management of FGIL. After taking over the management of FGIL, there's an investment of rupees 187 crores made by GL towards renovation and refurbishment of the factory to commence cable manufacturing. As of June 2023, Gloucester Limited resumed manufacturing of low voltage electric cables. As of October 2023, Gloucester Limited resumed manufacturing of medium voltage electric cables. Gloucester Limited has begun business-to-business sales of industrial cables and is in the process of beginning sales of control cables shortly. With the resumption of commercial production in operations in 2024, FGIL has generated revenue of rupees 92.61 crores. On 25th January 2024 is the impugned order setting aside the NCLT order on the following grounds. An agreement executed in violation of an injunction order is not void ab initio and remains valid because the parties to the transaction subject to the directions passed by a competent court. So this was one finding against us. The supplemental agreement was contingent upon vacation of the BIFR dated 10th of September 2001. Hence, with the repeal of SICA on 1st December 2016, GCL became the assignee of the trademark. The registration of the assignment is not mandatory here, because I believe this is an error in law, is not mandatory, and GCL became the owner of the trademark in terms of the supplemental agreement. D, the forensic audit conducted by the resolution professional did not report any transaction to be undervalued or preferential. Hence, the assignment deed cannot be held to be undervalued, and no action could be taken by NCLT under Section 43 and 45 of IBC without an application by the RP. Now, can I just pause here for a moment? As far as D is concerned, what the RP has said is that these agreements, they were not available with him at all. There was no cooperation by the original owners and the promoters and the directors, the key persons in management. And he received this just a few after the forensic audit had commenced and just before the forensic audit was submitted. So there was no occasion for the forensic auditor to look into any of this because they were not made available to the RP. That's in the context. So this really, in our respectful submission, is taking advantage of suppression. But anyway, serial number 30, the present appeal allowing so-and-so, which is what we have filed. The appeal has been preferred on the following grounds: that NCLAT had failed to appreciate that the agreement basis on which NGCL was claiming ownership of the trademark Gloucester is a document which was manufactured only to ensure that the trademark is retained by the erstwhile promoters of FGIL through their associate company GCL, that the supplemental trademark agreement was executed in violation of an injunction of BIFR, and the trademark Gloucester during CIRP of FGIL was unlawful in view of section 14(1)(b) of the IBC. Now, my lords, may I just take you to a few of the documents? Yeah. So, my lords, sorry, the first, if your lordship is just sees the BIFR order, just a couple of paragraphs. Page 100.
Starts at 93. Starts at 93, relevant at 100.
What do you want to show?
At 100, at 100.
Millers, would your lordship go to annexure A2?
Yes.
Volume 1, page 93. Summary of record of proceedings held on 9th September 2001. 10 September 2001, page 93 at the top. Please go to page 100, clause 8. The company/promoters were directed under section 22A of the Act not to dispose of any fixed or current assets of the company without the consent of the secured creditor and the Board of Industrial Finance and Reconstruction. In case the company was running, the current assets could be drawn down to the extent required for day-to-day operations, proper accounts of which would have to be maintained. Clause 8. So this is the restraint from any alienation of fixed or current assets. And this, as your lordships have seen, comes to be issued on 10/9/2001. Now please go to page 163. This is annexure A7. So this is during the tendency.
Yes.
Yeah, what is
This registration fits the LHD is talking about that 45 of the trademarks is not required. They expand it. Good.
So that's the main trademark.
The name of supplement. That's in 2017.
Does it refer to any parent agreement?
Yes, yes. It refers to the license agreement.
That's the main agreement.
Which was terminated by the supplement. Which was terminated in 2017 by the supplementary.
Yes.
I have further supplementary.
Deed of assignment. Actually, no requirement of deed of assignment if they say.
This document. But it is not just like 187.
Eight rows.
This is for 10 crores.
What is this now?
This is
This in 2020, FGI had represented that it continues to own the trademark and what it has given is only license. So they were conceding supplemental agreement from the lenders.
And the DRF.
And the DRF.
Section 22A of secret.
Yeah.
What's the secret one? That's right.
This ask them to give it.
106A3. PC myself.
Yes.
Today there is no challenge to the approved plan.
No, that's attained finality.
Final. The plan must have dealt with the trademark. What does it say about the trademark? Just see it in lunch.
Yes.
And suit is pending.
Yes.
What is the situation if the only claim of a party is a certain asset claimed to be the asset of the corporate debtor is really not the asset of the corporate debtor, it is my asset in view of these documents. Has to be heard in the suit.
Yes, it could be.
And
Certainly.
you are already using it.
You are using
Today also you
They
are.
have not got an injunction.
Yes.
Now, your point that the agreement is fabricated, it was never assigned in accordance with law.
Yeah.
It's a matter for the suit because to go into fabrication will be difficult in a 65.
All right, fair enough.
But the point about violation of the court order, of the VFR order, violation of the other point about registration.
Yes, registration.
All this can also be left to the suit.
Okay, I'll come back to your lordship. It may be possible. Why not?
All that can be left to the suit. Think about it, because there's a challenge.
But Manoj, that's on the understanding that these observations will obviously be effaced. No, just a minute.
Based on law. I mean,
Sorry?
no, we are not concluding.
No, I understand. But Manoj, if we are to consider going to the suit, then everything will be decided in the suit, including all defenses, etc. This NCLAT order ought to be. That's my submission.
Will it hear you?
Yes, of course. But we'll
not occurred because suit was mentioned.
Yes, discuss with me. We either remanded or renewed. Huh?
Registration today is in their favor. The suit registration today reflecting in their
Rectification.
My problem is that because of this clandestine and illegal registration which has taken place, you see, the earlier round in the suit ladder, I succeeded in resisting it because they had them come over here and filed it in the first instance. But today it becomes incumbent on me to endeavor to persuade your lordships that this registration itself could not have been done after the commencement of CIRP. It couldn't have been done.
See, what in a CIRP, all that happens is one set of management goes, the other set of management comes.
Yes, but there can't be an alienation.
Assets, etc. continue.
Yes.
One party gets up and says, new management says it's my asset when it is my asset. He has filed a suit. As long as there is no bar for that suit in law to decide whether this 2008 was predated, whether 14(1)B was violated is also a defense you can set up. It is not that a civil court can't examine.
No, it can examine. Supposing we were not in CIRP and all of this had happened. Supposing we were not in the IBC ladder.
Only a new management has come and you say that I have now paid 72 crores primarily for this mark.
Yes,
Without the mark, nobody would have paid. It's your case.
That's right. on the resolution plan, there was a question to me. So may I just place that before you as to what was stated, because there's a IA 55603. Lordships have that IA?
What's the idea?
It's Annexure A1 to the IA, page 10, where the resolution plan, first page.
Yes.
Your Lordships have it. It's styled as the amended resolution plan, correct? This is the one which was approved. And the statements with regard to trademark are at page 36. In the list of dates, only a small part of this had been extracted. Your Lordship has the subheading trademark.
Got it.
Yes. So I'll just indicate and then place it. It essentially sets out the history of our understanding on the basis of the papers and the documents, and and then what we submitted. So the trademark Gloucester bearing trademark registration number so and so, class 9, was registered in the name of FGIL with the Trademarks Registry, Government of India. FGIL is referred to the Board of Industrial Finance, Industrial and Financial Reconstruction. FGIL had granted a license right to Gloucester Cables Limited under an agreement of 2004. Then FGIL had also created a first and exclusive charge over the trademark in favor of GCL. FGIL had entered into a supplemental trademark agreement of 15 July 2008. Next paragraph, finally, GCL and FGIL entered into a deed of assignment dated 20th September 2017, wherein the above-mentioned trademark Gloucester has been assigned and or transferred to and vested in GCL with effect from the end of the statutory period of 1st December 2016 under the Sikh Industrial Company Special Provisions Repeal Act 2003. Further, the agreement inter alia includes below. I'll be placing this agreement before you. And then after A, B, and C, the resolution applicant believes that the said agreements have been entered into by FGIL with its related party GCL with the intention of transferring the said trademark to GCL with malafide intention. Or
About half an hour more?
so it will take a little longer.
Longer. We discharge the rest of the board. Otherwise,
yes, I'm grateful.
Learned Council will keep sitting. Mr. Subramaniam, you have that BPL matter right after this.
Just after this.
But it will take time.
No, I'm entirely in your lordship's hands, my lord. And my lord, I must mention, my lord, it was most magnanimous of your lordships to have discharged the board even before the midday recess today.
So we'll give you some date as early as possible.
Only, my lord, item 5, which is next, my lord, it is that matter where, my lord, unconditional stay is granted. Your lordships fixed it at top of the board today.
We'll give you all some dates.
Some
as early as. Yes.
Your Lordship, item number 45 also NEET PG matter that was also top of the board today. And urgency, Your Lordship, in that matter is several states have already invited applications for counselling.
NEET
matter, Your Lordship.
What do we do?
Your Lordship,
The Lordship both allows, Lordship may take up tomorrow.
Tomorrow and day after tomorrow will be fine. Keep it on Friday.
My Lord's.
Item 44.
Lordship, Friday top of board.
Okay, top up.
Item 44 is a statutory appeal. It is fixed today for today. The Lordship finds convenient, it can be set for some day. So there is an interim order operating against us.
We'll give you some date.
Lordship will keep you.
My Lords, may I please mention a matter which is listed before this Honorable Court today, my Lords, items.
You are Mr. Kuhar?
Yes, sir. The Lordship, I've got an exceptional memory.
You appeared in Gujarat?
I did, that's why I mentioned below your Lordship's
full bench, no?
An extraordinary memory.
That scheme.
Scheme, minority scheme. I'm so deeply obliged. It's been more than 10 years.
Oh, yes, 10.
So
yes,
Serial number 38. Can I get a fixed date? Because it's a leave to appeal. So it is.
Oh, yes.
Yes.
So Thakur is here?
Ms. Jani is here. He was to be here.
Today is 21st. 14th October? 14th October? Tuesday. Tuesday, top of.
I'm of late.
With my Lord's permission, may I please mention a matter, my Lord? My Lord, item number 44, item number 6, my Lords, I'm seeking a short date if possible. I am aggrieved. The impugned order has been stayed, my Lords, due to which I am deeply aggrieved when I appear for the respondent. I'm only seeking a short date.
Short date means what date? We'll give you some date.
My Lords, if it could be taken up at the top of the board this week, my Lords, because then the vacations start.
What will remain on the bottom then? Everything goes on top and nothing will remain at the
I
bottom.
understand, my Lords, but because of the stay on the impugned order, the criminal proceedings will be initiated against me, my Lords.
Criminal proceedings?
Yes, my Lords. My Lords may recall this is the matter with regard to declaration of bank as fraud.
Oh, that State Bank.
Indeed, my Lords.
Okay. You are relying on that judgment.
Indeed, my Lords.
Bank of India versus Rajesh Agarwal.
Indeed, my Lords.
Okay, we'll take it up.
Today, my Lords?
Not today, not today. Keep it on Friday.
Well, may I mention the NEET UG matter? The Lordship had kept it on top of the board because the NEET date tomorrow. Friday.
My Lord, matter was mentioned for today, Jagtaji infrastructure, item number 46. It was a section 11 application matter. So if you could give us a.
You are seeking appointment of an arbitrator.
Yes.
How can it has come here? It must not be national office.
Jagatji infrastructure.
Yes.
Yesterday you mentioned it.
Yes.
It's come from the High Court. High Court has declined.
Yes.
High Court has declined.
Yes.
On what ground?
They have taken the plea of accepted matter.
Huh?
Accepted matter. They have told us the claims fall under the accepted matter.
What is accepted?
But they are non-arbitrable.
Non-arbitrable. We'll see. After that break.
Thank you.
Sure, you can start.
Yes. Because I was on.
Yes, definitely.
Because I was on page 37 of that IA 55603.
We are on 37.
Yeah. So just after C, I'm just reading it. The RA believes that the agreements have been entered into by FGIL with its related party GCL with the intention of transferring the said trademark to GCL with malafide intention. Although the said transfer was barred in law under SICA and is also barred under IBBI during the moratorium period. The CD entered into this agreement during the intervening period between the admission under IBBI and repealing of SICA. The RA therefore believes that the trademark Gloucester has been assigned and or transferred to GCL is bad in law. The RA understands that the said...
1 second.
Sorry.
The plan, with this cloud,
And it's approved. The plan was approved.
with
Yes, of course it is.
Disclaimers.
Yeah, yeah.
So it's not a plan where plan says, very categorically that it is the asset, but it says these disputes are there, the supplementary agreement is noticed.
Yes, I agree. You're right.
And the only a comment of the RA
Yeah.
that we believe it is the trademark.
No, that's correct.
So this title has to be established elsewhere if there is a dispute.
No, I'm not for a moment suggesting if there is. But what I am going to show your lordships is now I'm going to take you to the documentation. Because the documentation is contrary to law. So if you're hit by the moratorium, you're hit by the moratorium.
You have accepted the plan.
No, I am the party, it's my plan.
No, it's your plan.
Correct.
And as approved.
This was approved.
Correct. Now this proceeding arises out of an application.
Yes.
By
I'll take you to that application.
CIL.
Yes.
Saying that look, it is my
Excluded.
which NCLT said that yes, NCLT held in your favor.
Correct.
Saying that it is the trademark of the corporate data.
Yes.
Now,
And included in the plan.
is that not in the teeth of the plan?
No, it's not.
This is a doubt.
No, I'll just respond. We have that last line, of course, is the assertion where he said that the corporate debtor, it is the asset of the corporate debtor of the resolution applicant now. But that's an asset. Yes, it's an assertion. But it's not. There can't be a self-serving statement over here, and I say that now in view of this and it having been approved, it is mine and nobody can question it. What we will be sorry.
So we can't go beyond the plan now. Nobody has challenged the plan. The plan.
No, the plan is, of course, is my. Yes, approved.
One can understand in a proceeding arising out of the plan.
Yeah.
Whether it should be sent back to the COC, etc. That doesn't arise now.
No, now we are well past COC, Manoj.
You can only say whether on this application, whether anything can be ordered.
Yes, that's the point.
So ultimately, it looks like more and more that the suit will have to be.
See, what he did was yeah.
Something like an assis veris, and if there is any dispute, that Telangana civil suit will have to be.
No, so can I just tell you how the sequence first? We got this plan, this plan is approved. He takes out an application which is disposed of on the same day as the approval of the plan, where he seeks exclusion of the trademark. Correct? There's no suit on this date. There's no suit on this date. He thereafter appeals. It's at that point of time, which I'll just give you the dates. It's at that point of time that the suit is thereafter instituted. Then he moves for an injunction in the suit. And that is declined because you can't be pursuing this remedy at two fora. That comes up all the way up to this court. So the suit, sorry.
For the moment, Brother and we assume the highest.
Yeah.
You succeed in getting his application dismissed.
That's it.
Where do you stand in the teeth of these governments in the plan?
No, it will stand excluded, my lord. His application will stand rejected.
Now he can't declare in the teeth of this disclaimer in the plan that you are the rightful owner.
No, but I am only today seeking his application to be dismissed as the NCLT did. That's all I can ask for today.
That's all you can ask.
What more can I ask for? What more can I ask for? I can only say that this is all malafide, and we will go into the RP's statements, etc., on his pleadings, etc., to say that once there's a moratorium, where is the question of the advocate on both sides saying that yes, I register and thereafter I consent?
But that's it for the civil code. Because
no, it's the dates are there. The dates are admitted. The moratorium, once the moratorium, IBC says moratorium comes in on a particular date, the asset can't move out. Once the asset can't move out, where's the question of registering with the trademark registry at that point of time? Then, so that's the way we look at it. So this application